Question number 351. What is not correct for the admissibility of the dying declaration under section 32 clause 1 of the Indian Evidence Act? Option A. The person making statement must have died. Option B. Statement must have been made as to cause of his death. Option C. It is not necessary the cause of death must be in question. D. It is not necessary that the statement must have been made in expectation of death. Here correct answer is option C. It is not necessary the cause of death must be in question. This is not correct for the admissibility of dying declaration under section 32 clause 1 of the Indian Evidence Act. Question number 352. Which of the following statement is not correct? Option A. The non-examination of the doctor endorsing the dying declaration does not have affect the evidentiary value of the dying declaration. Option B. Non-signing of the dying declaration by a literate declarant unable to sign does not render the veracity of dying declaration doubtful. Option C. When the relatives of the declarant are present during dying declaration, the dying declaration would not be relevant. And option D. The statement recorded in FIR may be treated as dying declaration. Here in this question it has been asked which of the following is not correct. Option C is not correct. Other options are correct. Question number 353. When a person proves his own statement constituting admission, or it may be proved on his behalf, when it is relevant as dying declaration, when it is relevant as admission, when it is relevant as confession, when it is only an oral admission as to the content electronic record. Here correct answer is option A, when it is relevant as dying declaration. Question number 354. Telling his wife that P's wife had called him to receive payments due to him, K leaves his house. After 2 days, his dismembered body is found in a truck. In P's trial for murder of K, the statement made by K to his wife is option A, inadmissible. Option B, partly admissible. Option C, inadmissible as it does not directly relate to K's death. Option D, admissible as it relates to the circumstances of the transaction which resulted in K's death. Here correct answer is option D, that is admissible as it relates to the circumstances of the transaction which resulted in K's death. Question number 355. A, an injured person went to police station himself and lodged the FIR at police station. Thereafter, A died due to injuries recorded in the FIR. Which is dying declaration under these facts and circumstances? Option A, depends upon the court. Option B, FIR report is admissible in evidence only when it is being corroborated by other evidence. C, FIR report is itself a dying declaration. D, FIR report can never be a dying declaration. In question number 355, correct answer is option C, that is FIR report in itself a dying declaration. Question number 356. In which of the following dying declaration is not relevant? Option A, when the declarant in his declaration speaks about the circumstances which has led to his death. Option B, when the declarant in his declaration explains the reason of his death. Option C, when the declarant in his declaration speaks about the circumstances which led to the death of the other person. Option D, when the declarant had died after the declaration. Here correct answer is option C, when the declarant in his declaration speaks about the circumstances which led to the death of other person is not relevant. Question number 357. Which one of the following statement is correct for admissibility of evidence under section 32 clause 1 of the Indian Evidence Act? Option A, dying declaration must be in writing. Dying declaration must be made under the expectation of death. Dying declaration may be verbal. Dying declaration must be made to magistrate. Here in question number 357, correct answer is option C, dying declaration may be verbal. Question number 358. Immediately before dying, signs and gestures by a victim whose throat was cut by the accused in answers to put questions indicated the person who had wounded him are admissible under section 6, 7, 32, 33. Correct answer is option C, that is section 32. Question number 359. A dying declaration recorded by the police officer in the form of FIR before the death of the author without obtaining certificate as to his mental fitness cannot be treated as dying declaration, cannot be read in evidence, cannot be treated as dying declaration, cannot be admitted in evidence. Here correct answer is option C, that is can be treated as dying declaration. Question number 360. About 6 months before he was murdered, the deceased wrote a letter to SP Jabalpur asking for the protection and stating that he apprehended injury from A and was in fear of his life. The letter is admissible under section 5, 6, 8 and 32. In question number 360, correct answer is option D, that is section 32. Question number 361. Which of the following will be inadmissible dying declaration? Oral dying declaration recorded on the basis of nods and gesture, dying declaration by signs and gestures, none of the above. Here correct answer is option D, none of the above, all are admissible. Question number 362. A statement to become relevant under section 32 clause 1 of Indian Evidence Act as dying declaration should have been made under which of the following circumstances? It should have been made in relation to the succession to his property after his death. It should have been made under imminent expectation of death. It should be in relation to the cause of his death or circumstances of the transaction that resulted in his death. It should have been made in the will executed by him. In question number 362, correct answer is option C. It should be in relation to the cause of his death or circumstances of the transaction that resulted in his death. Question number 363. Under Indian Evidence Act 1872, a declaration made in the course of business is admissible under. Correct answer is option B, that is section 32 clause 2. Question number 364. In which of the following categories an opinion contained in the book of a deceased expert which is produced in evidence in a court is put? Oral evidence, documentary evidence, evidence under section 32, evidence as hearsay evidence. Here correct answer is option C, that is evidence under section 32. Question number 365. Which subsection of 32 of Indian Evidence Act makes the fact of relations between the parties who are not alive relevant? Subsection 1, subsection 3, subsection 5, subsection 6. Correct answer is option D, that is subsection 6. Question number 366. Relevant facts to consider a statement under section 32 of Evidence Act are when it relates to cause of death, when it relates to existence of relationship, when it is made in will or in deed relating to family affair, all of the above. Correct answer is option D, that is when it relates to the cause of death, when it relates to the existence of relationship, when it is made in will or in deed relating to family affairs, all of the above are the correct answer. Question number 367. Which of the following provisions of Indian Evidence Act permits evidence recorded in one case to be considered relevant in a subsequent proceeding? Correct answer is option D, that is section 33. Question number 368. Evidence of a witness in a previous proceeding would be admissible under section 33 of the Evidence Act only if the adverse party in the first proceeding had the right and opportunity to cross-examine the witness. The statement is true. Question number 369. In a suit after the cross-examination of a witness, the plaintiff was returned for presentation to the court of competent jurisdiction. Before proceedings started in the court, the witness died. His deposition is admissible under section 32, admissible under section 33, admissible under section 6, inadmissible in evidence. Correct answer is option B, that is admissible under section 33 of Indian Evidence Act. Question number 370. Under which of the following circumstances will the evidence given by the witness in a judicial proceeding by relevant subsequent proceedings under section 33 of Indian Evidence Act 1872, when the witness cannot be found, when the presence of the witness cannot be obtained without undue delay or unreasonable expense, when the witness is dead, and option D, all of the above. Here correct answer is option D, that is all of the above. Question number 371. In which of the following cases the evidence given by the witness will not be relevant under section 33 of the Evidence Act? Correct answer is option A, when the witness is staying abroad. Question number 372. Under section 33 of the Evidence Act, evidence of witness A recorded in an earlier judicial proceeding can be produced in another judicial proceeding where witness A is alive. Option B, witness A is alive and is incapable of giving evidence. Option C, criminal proceedings are pending against the witness A. Option D, there was no right but opportunity of cross-examination of A was granted in the first judicial proceeding. Here correct answer is option B, witness A is alive and is incapable of giving evidence. Question number 373. Relevant entries in the book of account alone, option A, are sufficient to charge any person with liability, cannot be taken into consideration in a criminal trial, are not sufficient to charge any person with liability, can help a judge in deciding a suit. Here correct answer is option C, that is are not sufficient to charge any person with liability. Question number 374. Which of the following is a leading case on entries in the books of accounts when relevant? Correct answer is option D, that is L.K. Advani versus CBI. Question number 375. A sues B for rupees 1000 and shows entries in his account book showing B to be indebted to him to this amount. The entry is not relevant, relevant, does not have evidentiary value, inadmissible. Correct answer here is option B, that is relevant. Question number 376. A sues B for rupees 1000 and shows entries in his accounts book showing B to be indebted to him to this amount. Under Indian Evidence Act, the entries are relevant but are not sufficient without other evidence to prove the debt. The entries are sufficient without other evidence to prove the debt. Option C, the entries are not relevant but are sufficient without other evidence to prove the debt. And option D, the entries are neither relevant nor sufficient to prove the debt. Here in question number 376, correct answer is option A, that is the entries are relevant but are not sufficient without other evidence to prove the debt. Question number 377. X sues Y for rupees 1 lakh and relies on entries in his accounts book showing Y to be indebted to him in this amount. To prove the debt, The mere entries are sufficient. The entries are not admissible and independent evidence has to be adduced. The entries are relevant but are not alone sufficient to establish the liability of Y. The entries cannot be relied upon. Correct answer is option C, that is the entries are relevant but are not alone sufficient to establish the liability of Y. Question number 378. In which section of Indian Evidence Act deal with proof of customary practices? Option A, section 34, 46, 47, section 33, 45, 48, section 35, 47 and 49, and option D, section 35, 48 and 49. Here correct answer is option D only, that is section 35, 48 and 49. Question number 379. Which of the following sections of Indian Evidence Act deals with the relevancy of statement as to any law contained in law books? Correct answer is option B, that is section 38. And question number 380. Which one of the following section of Indian Evidence Act has been substituted for the old section by the Information Technology Act 2000? Correct answer is option A, that is section 39. Question number 381. Section 40 to 44 of Indian Evidence Act deal with the relevance of characters, opinions of third persons, judgment, decree and orders. Statements made under special circumstances. In question number 381, correct answer is option C. Section 40 to 44 of Indian Evidence Act deal with the relevance of judgment, decree and orders. Question number 382. Under which of the following sections of Indian Evidence Act the previous judgments are relevant to bar a second suit or trial? Options are section 39, section 40, section 11, section 42. Correct answer is option B, that is section 40. Question number 383. The principle of res judicata provided in which of the following section of the Indian Evidence Act? Section 140, section 40, section 160, section 164. Correct answer here is option B, that is section 40. Question number 384. Under the Indian Evidence Act 1872, which of the following is an exception to the rule of res inter alias judicata mulam alias prejudicatum facit? Here correct answer is option C, that is section 41 and section 42, that is both A and B. Question number 385. The decision of a probate court is option A, a judgment in rem, B, judgment in personam, C, conclusive proof, D, foreign judgment. Correct answer here is option A, that is a judgment in rem. Question number 386. Which kind of jurisdiction is not mentioned under section 41 of the Indian Evidence Act 1872? Probate, admiralty, insolvency, revenue. Here correct answer is option D, revenue. Revenue jurisdiction is not mentioned under section 41 of the Indian Evidence Act, whereas probate, insolvency and admiralty jurisdiction is mentioned in section 41 of the Indian Evidence Act 1872. Question number 387. Which one of the following is a judgment in personam? Correct answer is option B, that is a final judgment in a suit for restitution of conjugal right is a judgment in personam, whereas a final judgment in a suit for divorce, a final judgment in a suit for insolvency, a final judgment in a suit for admiralty matters is judgment in rem. Question number 388. The presumption under section 41 of the Indian Evidence Act is a presumption of fact, a rebuttable presumption of law, a irrebuttable presumption of law, a presumption of law and fact. Correct answer is option C, that is an irrebuttable presumption of law. Question number 389. Under Indian Evidence Act, the judgments of Admiralty Court are relevant in. Correct answer is option C, that is section 41. Question number 390. A prosecutes B for stealing a cow from him. B is convicted. A afterwards sues C for the cow which B had sold to him before his conviction. The judgment against B is. Correct answer is option B, that is irrelevant between A and C. Question number 391. Which of the following judgment is irrelevant under section 43 of the Evidence Act? Judgment of an insolvency court, judgment of a matrimonial court, judgment of a probate court, judgment of a criminal court. Here in this question it has been asked which of the following judgment is irrelevant under section 43 of the Evidence Act. Correct answer is option D, that is the judgment of a criminal court. Question number 392. Which final judgment, order or decree of a competent court among the following is a judgment in rem? Option A, in a money suit. Option B, in a suit for permanent injunction. Option C, in exercise of matrimonial or insolvency jurisdiction. And option D, none of the above. Here correct answer is option C, that is in exercise of matrimonial or insolvency jurisdiction. Question number 393. Kalu prosecutes Khema for stealing a car from him. Khema is convicted. Kalu afterwards sues Ganesh for the car which Khema had sold to him before his conviction. The judgment of conviction of Khema in the suit between Kalu and Ganesh is relevant, irrelevant, relevant only with the prior permission of the court, and none of the above. Here correct answer is option B, that is irrelevant. Question number 394. A prosecutes B for adultery with C. Wife of A B contested by denying the allegation. B was found guilty and convicted in the said case. Subsequently, C was prosecuted and charged of bigamy on allegations that she had married B during subsistence of her marriage with A. C contested by denying that she was ever married to A. In the case against C, the judgment in the first case against B is, here correct answer is option B, that is irrelevant. Question number 395. The findings of the criminal court are inadmissible in a civil suit. Reason: acquittal or conviction in a criminal case has no evidentiary value in a subsequent civil litigation except for the limited purpose of showing that there was a trial resulting in acquittal or conviction, as the case may be. Here option A, both A and R are true and R is the correct explanation of A. Option B, both A and R are true but R is not the correct explanation of A. C, A is true but R is false, and D, A is false but R is true. In question number 395, correct answer is option A only, that is both A and R are true and R is the correct explanation of A. Question number 396. Evidence Act judgment of a civil court is binding on the criminal court under all circumstances. The statement is false. Question number 397. A prosecutes B for stealing a cow from him. B is convicted. A afterwards sues C for the cow, which B had sold to him before his conviction. What will be the importance of the judgment of B's conviction between the suit A and C? Here correct answer is option B, that is irrelevant. Question number 398. Any party to a suit may show that any judgment, decree or order which is relevant for a dispute under section 40, 41 and 42 of Indian Evidence Act and which has been proved by the adverse party is delivered by a court not competent to deliver it. Here correct answer is option A only. Question number 399. Relevancy of expert evidence for the purpose of Evidence Act is contained in. Correct answer is option C, that is section 45 to 48. Question number 400. The general rule is that the opinion or belief of a witness is irrelevant. Certain exceptions to this rule have been laid down in Indian Evidence Act. The sections contained these exceptions are option A, section 52 to 55, section 10 to 15, section 6 to 9 and option D, section 45 to 51. Option D here is the right answer.